We have 4 cases to talk about today with updates. Time is ticking on many of these cases, and for some trials right around the corner, but it comes with some drama. When doesn't it? First, we'll talk about Letecia Stauch. There's a new plea that was submitted by Leticia, and it is not guilty by reason of insanity. According to Cornell Law School, it says not guilty by reason of insanity is a plea entered by a defendant in a criminal trial where the defendant claims that they were so mentally disturbed or incapacitated at the time of the offense that they did not have the required intention to commit the crime and are therefore not guilty. It says the Bouvier Law Dictionary explains that not guilty by reason of insanity is a plea essentially admitting the defendant committed the act of the offense, yet denying responsibility because the defendant lacked the capacity to act with criminal intent at that time. So if we also go, I found an article in Psychology Today, and it also talks about not guilty by reason of insanity. And it says it's a legal defense. It addresses mental status at the time of the alleged crime. Competency to stand trial has to do with the person's present mental status at the time the person returns to court. In fact, the insanity defense is used in only 1% of all criminal proceedings, and its success rate is only 25% of that 1%. Therefore, less than 1 in 400 defendants are found not guilty by reason of insanity in this country. A small sample for such intensive coverage that leads us to believe not guilty by reason of insanity is used often as a defense. Based on current statistics, it is not, and when used, is rarely successful. In general, it says every crime involves 3 elements: actus reus, which is the act or conduct; mens rea, which is the individual's mental state at the time of the act; and third, there has to be a connection between the act and the effect. So now, because of this, the trial date is pushed out, and it will be set after Leticia gets evaluated again. And she's had 2 competency evaluations already and deemed competent. And the judge told Leticia that because of this new plea, she could be given a polygraph during the evaluation, and if she makes any confessions, that it will be admissible in court. Now, I just want to take you down memory lane. Remember when she actually submitted or tried to hire somebody to create a fake polygraph test? That actually happened. And the judge also told her that by pleading not guilty by reason of insanity, she's waiving any responsibility of previous mental health records. Leticia has a list of charges against her in regards to Gannon. She also has other charges because she attempted to escape out of the jail. Remember when she tried to bribe another inmate and she wanted to use a broomstick to escape, and she was measuring herself and how she can escape. And she also attacked a deputy after being arrested in South Carolina right before Gannon was found. They arrested her, then Gannon was found, and then she was transported. And while she's being transported back to Colorado Springs, she decided to basically slip out of her handcuffs and attack a deputy. They had to stay overnight, and then they continued on and went to Colorado Springs. So that'll be separate from, obviously, this. Leticia's attorneys filed a motion to waive a jury trial because of the pre-trial publicity that they're concerned about and not being able to find a fair jury pool. District Attorney Michael Allen said he wants to see the results of the evaluation first before going to that spot. And we already saw that she's been deemed competent twice, so I think 3rd time's a charm. Let me know your thoughts. The judge postponed the decision and said wait until the trial comes and gets to the jury selection. So let's talk a moment again about her insanity plea, because this is interesting to me. She's been trying to act, and I say act because she's had 2 evaluations. She's competent, but she keeps pulling these stunts in court, and they are obvious stunts, such as spinning around, flicking on the lights, and on and off. And then in the same breath, she wants to represent herself, and she's confident that she can, blah, 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 blah. So I thought maybe Leticia knows that this isn't going to end well, and that's why the change. And maybe now she's thinking, well, I'd rather be in an institution than in a prison, because you know that's not going to go over well if she's sent to a prison being child killer if she's, convicted. What are your thoughts about this? That's how I feel. Now, it's interesting to me that she did change the plea, but I'm wondering if she's going, this isn't sitting well. And this girl has more games than a carnival. So Leticia's next court date is March 17th. We'll find out what happens with her third competency. Let me know below what your thoughts are. It's unfortunate that the trial is pushed out. That gives more time to wait, and it's torture for the family. Let's just get this done. But I fully believe in District Attorney Michael Allen. He has an impressive resume, and I don't doubt him one bit. And because of everything that's happened in the case that we know of, it doesn't look good for Leticia. Playlist is down below. Check them out. I was reviewing a few, and it's interesting about some letters or some statements that she wrote right in the beginning. Now let's go to Barry Morphew. Barry has been granted a change of venue, and his trial will now be held in Fremont County, which is in Canyon City, and it's about 1 hour east of Salida. And in court last week, there was some things that were announced that statements made by Suzanne's friend Sheila Oliver regarding domestic abuse will not be admissible in court. It was said, though, texts will be. Now, the judge ordered also the prosecution to hand over to the defense all the data from Suzanne's Range Rover and data from her iCloud no later than 2 weeks from February 10th, which makes it the 24th of February, and that's when there's another hearing in Barry's case. And Barry now has a new trial date. It's been moved up. It's now at April 29th until June 3rd, which makes it a 5-week trial. And I've been diving into the affidavit and already finding some interesting information and connecting some dots. But I'm finding that some of the specials that are made on the case, specifically there was one not too long ago and I covered that, and I'll put that in the description box, but it was very Suzanne-sided about her affairs and stuff, but it didn't show about Barry, and he's no angel. So I'll be getting into that. Now, I'm already getting threats on this case, and I remember now why I stopped kind of diving into it, because it's getting ridiculous. But I guess that's because I'm getting to the truth. What do you want to see me dive into? Let me know below. Let's go to Lori Daybell. There was a closed hearing on Friday the 11th, and in it they discussed Lori's mental competency. Now, the prosecution and the defense asked for a status update. They wanted a hearing, and the hearing was sealed. But Judge Boyce said, the court finds a compelling interest is at stake in the need to preserve a fair trial, and no reasonable alternative exists to protect this fundamental right except to conduct a closed hearing at this time. Now, last month on January 13th, they received a sealed forensic mental health evaluation. Now, back in September, the judge actually gave 180 days to reassess Lori's competency, which actually puts it now to March 22nd. Now, there aren't any currently scheduled hearings at this time, so we have to wait. What are your thoughts on this? Do you think Lori's legit and she isn't competent, or do you think she's, faking it? In a recent special that I covered, and Lori's brother Adam was on it, according to Adam, their mother, Janice, said that she's been talking to Lori, and Lori's the same Lori that she ever was, and nothing's really changed. So I'm really curious about that. Let me know your thoughts. And I'll link below to the special. I covered it in a half an hour as opposed to an hour and a half that it actually was. Now on to Chad Daybell. Chad's lawyer, John Pryor, is apparently working hard. And he's asking the court for an extension to file a motion to dismiss Chad's case. He's also working on severing the case as well. Now, there was a lot of push from John, as per usual, and he complained that because the grand jury transcript was so voluminous that he needed more time, but this is like 90 days that he had, and Rob Wood was pushing back as well. So the judge gave him until March 9th to file the motion, and by March 23rd, they're going to hear this motion to dismiss the case. This should be interesting to have the case dismissed, or try to. Of course, it'll be interesting to hear John Pryor's take on it, and some whining that we'll hear, in my opinion. Let me know your thoughts about this. I find it crazy it will even get dismissed. I just feel like there's no way it'll get dismissed. Let me know your thoughts. Chad's trial is supposed to be held in January of 2023. Do you think it's going to get dismissed? Check out the recent special on the case and check below for my coverage on Leticia and for Barry. Don't forget to subscribe, hit that notification bell. Thanks so much for watching.